Dr. Alias. The topic that our group has chosen to present is discuss the application of sales-based contracts in housing finance, Bay Bithaman Al-Ajil, BBA. My name is KH'NG and my metric number is 274056. The part that I am going to present is Introduction. In the modern days, the position and the presence of Islamic banks in the world are increasingly commonplace through the Islamic windows and providing certain Islamic financial services or well-developed Islamic licensed banks. The fundamental practice of the Islamic finance is constituted by the Sharia by observing its tenets, regulations, and principles. It is important to note that any person who intended to purchase houses, especially involving transactions that fall within the scope of Housing Development Control and Licensing Act 1966 and its regulations will apply for home financing from Islamic banks. After a briefing on the Malaysia background of Islamic home financing system, we'll delve deep into the root on how the Islamic home financing of BBA contract works in Malaysia by supporting our point of view with forceful arguments. I will now pass the floor to the next presenter.
Good day to Dr. Alias and my fellow friends. My name is Kayao and my metric number is 272807. Today I will present the part of Bay Bithaman Al-Ajil BBA. BBA is one of the common facility agreement under Islamic financial institutions. The keyword of BBA is deferred payment sales. It can be defined as a contract of exchange where the commodity exchange is delivered immediately, whereas the price is deferred or is paid by installment. Based on the legality and authority, Al-Quran provides the revelation for BBA, which is but Allah had permitted trade and forbidden riba. This is because the Prophet prohibits riba and creates the BBA concept to provide loan to the public. In BBA, the financial institution will apply the sales and purchase concept in the loan transaction. Moving to next, there are 4 conditions in BBA. First, the due date of payment must be specified in clear and precise way. In other words, the BBA contract must state the period and the fixed payment. Second, the deferred payment may be more than the cash price, but it must be fixed at the time of sales. The price may be higher than the cost price because it includes the profit margin for the bank. Once the price is fixed, it cannot be decreased or increased. Third, the buyer may be asked to promise that in case of default, he will donate some specific amount for a charitable purpose. And fourth, if the commodity is sold on installment, the seller may put a condition on the buyer that if he fails to pay any installment on its due date, the remaining installment will become due immediately. It can be referred to the case of Zulkifli bin Abdullah and Afim Bank Berhad, where the bank claims the remaining of the installment immediately when the customer defaults the payment. So that's all from me for the concept of BBA, and I will pass the floor to my members. Thank you.
Good day, sir. My name is Lochan with metric number 272921. Now I'm going to briefly explain about the concept of BBA housing finance. Regarding the Malaysia Islamic housing finance, the element of interest which is known as riba is prohibited under Sharia law. A Sharia-compliant contract can be made in a number of ways to pledge that the revenues obtained from the transaction is lawful, namely Bay Bithaman Al-Ajil, BBA, Musyarakah, and Ijara. BBA is when a bank sells a Sharia-compliant asset such as a property or a commodity to a customer in cash or in installments. Musyarakah is when the bank and the customer jointly own a property. The customer will pay the bank in installments until they have complete possession of the property. Ijara is when a bank leases a property to those who make rental installments on the asset. When the lease expires, the client will have the option to purchase the property. Let's move on to the BBA housing finance. The Bay Bithaman Al-Ajil is the most common method of financing used by Islamic banks in Malaysia. One co-owns the property with a bank and makes payments every month to buy back the bank's portion of the property. The property will be transferred to the customer through a gift transfer, also known as hibah, once he has made the final payment. The agreed upon profit margin will be included in the bank's selling price for the property, and monthly installments occur for a particular amount for a period. The selling price, repayment duration, and financing percentage margin determine the fixed monthly payments. Finally, almost all Islamic banks employ the commonly used BBA principle. The BBA appears to be gaining traction in Malaysia, since Islamic banks in our country are obligated to obtain clearance from the internal Sharia advisory boards before seeking permission from Bank Negara Malaysia and the Central Sharia Advisory Council. Such variations in the Islamic housing finance product will remain under strict control. That's all for my part. I will pass the floor to the next person. Thank you.
Hello everyone, my name is Amelie Gang. My metric number is 272767. Now I would like to present about the practice of BBA house financing. When Bank Islam Malaysia Berhad was founded in 1984, it introduced the BBA house financing idea to Malaysia. BBA house financing is basically referred to a proceeding which is the bank bought a property that the consumer had already purchased from the developer. Subsequently, the bank sells the related property to the customer at a consent price, which includes the bank original cost of the property plus the bank profit margin, and permits the customer to pay in deferred payment over a period and in the way agreed. During the buying and selling proceeding, financing documentation must be implemented before the distribution of the financing sum. Normally, we use three important financing agreements, which were property purchase agreement, property sales agreement, and deed of assignment. First, let me introduce to you property purchase agreement, which is PPA. PPA is a Sharia compliant agreement between a customer and a bank in which the bank purchase a customer asset and then sell it to the customer on a delay payment basis. PPA has given customer more responsibilities because the customer is liable for additional fees in relation to the assets and PPA, such as tax, evaluation, stamp duties, travel fee, charges, legal expenses, lawyer fees, and so on. Following the PPA's implementation, the parties should undertake the property sales agreement, which is PSA, immediately to illustrate the activity of reselling the same asset to the customer for delay payment, including the bank's profitable ratio. Granting the settlement, the bank has the right to be a landholder on any assets owned by the customer. Furthermore, the customer agreed to compensate bank and pay all bank payment in case of the customer infringe any terms of the S&P agreement. The bank is not the property's developer. It will not be responsible for any dispute arising from imperfection in the assets caused by the faulty craftsmanship. The last financing document that I will introduce to you today is deed of assignment. This is a contract between the bank and the customer in which the latter accepts to transfer to the former all his right and interest in the asset as security for loans when customer discover the product sold has a defect. This is called option of defect. Option on defect assists to ensure the fulfillment and the benefit of both parties and to find the right balance among the deficiencies, pricing, and purchasing parties' interests. So that's all from me. I will pass the floor to the next presenter.
Good day, sir. I am Hui Hong with matrix number 273410. I will now continue with our group presentations regarding the four elements of BBA house financing contract under the recognitions of Islamic law. First and foremost, the first element that is compulsory to be fulfilled in a BBA house financing contract is that the subject matter must be in existence. Islamic law makes its position clear that if the subject matter is absent at the conclusions of the contract, the said contract will become a fraudulent contract that is prohibited by Islamic law. To make the things clearer, even if the house could probably exist after the conclusions of the contract, or even if it's established that the complete house would come into existence in the future, the contract is still void in the eyes of Islamic law. Secondly, Islamic law requires that the subject matters can be delivered in order to validate a contract. The subject matter has to be delivered to the rightful parties of the contract, irrespective of whether there exists legal ownership or beneficial ownership. In the other words, if the parties can ensure that the transfer of ownership is included in the delivery of property, the contract will still be recognized under Islamic law, even though the ownership is just beneficial in nature. Moving on, the third criteria that has to be stratified is that the subject matter can be ascertained. This element is important as it aims to prevent hardships, disputes, and losses caused to the parties. In respect of these requirements, different schools of thought are having their own different opinion. As an example, Hanafi school view that the ascertainment of the subject matter can be proven by pointing out the place where the house is located, even if it is hidden, but Maliki school hold the view that the parties must see the property virtually, except in the events that it is impracticable, where the pending completion house must be ascertained by description. Last but not least, the suitability of subject matters is also one of the essential elements in the BBA house financing contracts. It is necessary for the subject matter to be fit for transactions and usage besides suitable for commercial value. Hence, a contract will be rendered as void due to the absence of subject matter suitability if the house is submitted to be abandoned and cannot be occupied by the purchaser. That's all from me.
Hi, I am ELVIS and my matrix number is 272967. So today I'm going to have an introduce of the Afin Bank versus Zulkifli Abdullah. In this case, the defendant called Zulkifli has bought a house and he has paid the deposits while the remaining sum he gained for the financials with a bank under the Islamic system of BBH. After paying some of the amounts, the bank was asked to reconstruct the facility, which the tenure extended from 18 years to 25 years. Again, the defendant defaults in making payments. Hence, the bank commenced an action to order an order of sales and also to recover some in the event, which is for full tenants. Alright, so the issue is that what's the amount that the defendant should pay in the event of default in case of BBF facility, where he has already paid the amount of fee by installment, which were originally to be paid over 18 years tenures. In this case, the judge dismissed the bank's claims for the sum for the full tenures and only granted the profit up to the date of judgment plus penalty and also the daily profit until the full settlement of the judgment sum. The rationale behind this case is that the BBF financing is a series of equal money installments. Hence, the profit margin is also calculated based on the period of the tenures. If the customer is not given the full tenure to pay the price, and the bank is also not entitled to claim for the profit margin for the full tenures. As to allow the bank to do so means that the bank is able to earn profit twice upon the same sum at the same times. Besides, the profit margin charged on the unexpired part of the tenures is an unearned profit and not actual profit, therefore cannot be claimed under BBA, otherwise it will contradict the principle of the Islamic banking. That's all for me. Thank you.
In conclusion, the element of the practice of beneficial interest that consists in the Islamic home financing of BBA contract is general, and it plays an important role to the contemporary development of the society on the ground of general consideration of public interest and equitable consideration. In order to stick with the Islamic principle, the practice of beneficial interest should be applied carefully to prevent any injustice circumstances. The issue of gara need to be prevented during the application of sales-based contracts in home financing, as this issue is strongly prohibited by the Islamic law. Hence, the documentation involved like PSA, PPA, and DOA must be clear and avoid ambiguous terms so that the purchaser's interest can be protected. That is the end of our group's presentation. Thank you.